and welcome. You're watching the news with me, Apeksha Srivastava. Let's straight away get to the top story of today. In a rare instance, the Bombay High Court has upheld two orders of the civil court in Nanded in Maharashtra. Now, the court has directed a wife working as a teacher to pay 3,000 rupees per month as maintenance to her former husband. Now, upholding the orders passed by a local court, the High Court has directed the woman who is working as a teacher to pay 3,000 as alimony to her ex-husband. Now, the civil court has asked the headmaster of her school to deduct 5,000 rupees from her salary every month and deposit the same amount with the court towards unpaid maintenance since August 2017. Radhika joins us live for more on this. Radhika, it indeed is, from the looks of it, a progressive move by the court. But take us through what exactly has the court said? What is the rationale behind this judgment?
That's right. This is a very significant, consequential and far-reaching order as far as the Aurangabad bench of the Bombay High Court is concerned. This is an order that has been upheld by the Aurangabad bench of the Bombay High Court. Earlier, a Nanded court had given this particular order, which has been upheld by the higher court. Now, as far as what the order states, before I come to the order, what this particular individual, the husband, had gone to the court seeking maintenance on the grounds that he was unemployed, he had faced several health issues, and that he had given up on several dreams and aspirations of his to sort of support the wife as far as her career is concerned. So he had made several compromises in that marriage in terms of finances, in terms of career. Therefore, he's entitled to the maintenance is what he has said in that particular petition that has been upheld. Now, as far as what the court is saying, of course, court has said that yes, he's entitled for it and therefore has asked the woman to pay 3,000 every month. And the court also said that as per section 24 and 25 of the Indian Marriage Act, Hindu Marriage Act, in fact, he is entitled for it, and an indigent spouse, in that case, in this case, indigent spouse is the husband. Indigent spouse, irrespective of whether it's the wife or the husband, is entitled for maintenance. So that's what the court has upheld, that it doesn't matter if it's the wife or the husband, but if one of them were in a financial strain of sorts during the marriage and had sort of compromised in any way, that person is entitled for financial support, is something that the court has indicated through its order.
All right, Radhika, thank you so much for joining us with all those details. In fact, we're also being joined by Rekha Agarwal, a family court lawyer, as well as Amit Deshpande, men's rights activist. Both of you, thank you so much for joining us here on Mirror Now. I'd like to begin with you first, Rekha. You know, how do you look at this judgment? Do you think it's a progressive judgment, or do you think that it's going to make it even more challenging for women to fight for their rights?
I'm very glad that this judgment has been passed, and that too by a civil court. The High Court has only upheld the order which has been passed by, in fact, this order must have been passed by the Nanded Family Court. That is the court which has got jurisdiction in such matters. So I'm so happy to see this kind of a judgment, because at a time when we are talking of gender neutrality and gender equality all the time, and the Constitution of India also provides that there can be no difference or differentiation between men and women. Their rights are equal in law, especially in matters of family law. If a woman has got the right to ask for maintenance under Section 24 and under Section 25, the same right, ipse dixit, also follows upon the husband. This is, I think, there are two things which this order shows. Number one, that it is a case of role reversal. Here, the man has clearly said that it's not always the woman who's suffering and looking after the house and looking after her husband and bringing up the children. Here, the man has clearly said that that I have sacrificed my dreams and ambitions to look after the house so that the wife can complete her education, become a teacher, and get employment in a school or college wherever she's been teaching. So number one, it shows that the times are changing. It is not necessary that the wife should be working, that the husband should be working always, and he should be the breadwinner. This judgment also shows that yes, more and more women are now getting the opportunity, and husbands are realizing the needs and the aspirations of the wife also, and encouraging her. And two, that yes, if if the wife has got a right to ask for maintenance at any point of time, so does the husband have the right to ask for maintenance. And the High Court has only upheld that order. So, and that to a lady judge, Justice Bharti Dhangre has passed this order. So I'm very glad, being a lady myself, that, that now we are not always looking at as women as the bechara, oh God, she's the sacrificial goat, she's the one who is always bearing the brunt of all the, liabilities and that are there in a marriage. So I think that it's a very, very far-reaching, this judgment has got far-reaching consequences, and it will also make the men feel stronger, that all the husbands who may be facing any kind of matrimonial litigation, they'll also feel better that yes, it is not always that that we have to pay to the wives. If the situation ever arises and we feel that the wife is earning more than the husband, or the husband is not earning at all, the husband has also got a right to ask for maintenance. At the same time, this is a big call. It's a wake-up call to all those women also, who unnecessarily may drag their husbands to the court. It's always that it is the woman who's asking for maintenance. Very rarely do men ask for maintenance. So it's a wake-up call, and it's a warning for even all the wives to realize that tomorrow they may also have to bear the brunt of paying maintenance to their husband. Of course, at the same time, in our country, I must also admit the fact that the law may say whatever it is, but generally it is the woman who's suffering. So a balance has to be drawn in society, and that is what this judgment has shown very clearly, that under Article 14 of the Constitution, all men and women are equal.
Absolutely, Rekha Agarwal. In fact, just stay on with us. I'd also like to take, opening comments from Amit Deshpande. So, what do you have to say about this judgment? Do you think this is going to make men feel stronger?
First of all, I mean, it's a very welcome judgment. But in my, more than a decade association with following matrimonial laws, I have seen only this second case wherein a husband has got maintenance from his wife. This is like the earlier case I had heard was about in Pune, a handicapped man had fought for about 12 years, and then he had got some meager 2,000 rupees, 3,000 rupees. And this is the second one that I have come across. I welcome it, but I think this is too few and far in between when we are talking about equality. We have always been seeing the gender roles as men being the protector providers and women being the caretakers. We are all fighting for the gender equality to bring neutrality in our stances. And now the second judgment has come, in my knowledge, in such a long duration. I think this should become more and more common. And not only this, I think there is also a law for vagrancy of women. The same thing should be applicable for men also. More number of men are homeless in our society. More number of men commit suicide. There is a lot of things that go against men which is not spoken about. I think in terms of vagrancy, the feminists should help us to make CRPC 125 also gender neutral, as well as this will be a stepping stone to bring in gender neutrality in the domestic violence law. I think this is a start, but this should be followed up. It should not be just left.
Absolutely, Amit. In fact, you've made a very valid point there, and that takes me to my next question to you. Given, our social setup, do you think that this judgment, in a way, if in future cases, if husbands end up proving their inability to pay the alimony, will this in a way be a setback for women? Because now, we know how our social, setup is, where women are largely dependent on men for most of their, financial expenses. So if tomorrow, if men say that, we cannot pay the alimony, then do you think that this will put the women at a disadvantage?
Not really. I mean, I don't think so. That is the case. We have had so many cases wherein women are asking for alimony even after 20 years of marriage. I mean, I had seen a case wherein the second husband died, and then the woman went back and asked alimony maintenance from the first husband, who had 2 grown-up children. The Supreme Court has time and again given relief to women, saying that, okay, they are entitled to alimony even after divorce. There are so many CRPC 125 cases filed after divorce. So this is happening for women who might not even actually practically deserve it. So when this is the same law is there, the same system is there, now men are just coming out and asking for help, seeking support. I think this is the time to support them, and just not see, when women were asking for alimony, we had not seen it being that it is anti-men. So when men are asking for alimony, it should not be seen as anti-women. That's all.
An interesting point there. Rekha, do you think that, we've seen the judgment, these laws are applicable only to the Hindu Marriage Act. But do you think that such, gender agnostic family laws can be a reality across communities in India?
Except for the personal laws, in the Indian subcontinent, in that perspective, if I were to talk about, then if we talk about the personal laws of Muslim community, they are governed by their own personal laws in matters of matrimony and maintenance. So this will not be applicable to them. The time has come now to have a uniform civil code. Once there's a uniform civil code, then of course all these laws will be applicable to everybody, irrespective of their religion. But as of now, the Hindu Marriage Act, we are talking right now about Section 24 and Section 25 of the Hindu Marriage Act. There are analogous provisions, in other laws, for example, even under the Special Marriage Act, where two people of two different, religions may get married. A Hindu and a Muslim may get married under the Special Marriage Act. So there'll be analogous provision in that. Comparable to Section 24 and 25 of the Hindu Marriage Act. And similarly, but however, in the personal laws, the Hindu Marriage Act will not apply. So in case we have a uniform civil law, then this problem of personal law will not come, where either a woman or a man may be debarred from claiming maintenance. Having said that, I just want to take on and continue where the other panelist, Amit, was talking about that, women suddenly come forward and ask for maintenance, or there is also the vagrancy situation where a husband may be into. So just, for the benefit of all the viewers of this program, in the year 2020, Justice Indu Malhotra, who's now superannuated from the Honorable Supreme Court, she passed a landmark judgment, which is called the Rajneesh versus Neha judgment. That judgment is applicable pan-India. And on the basis of the judgment, an affidavit, or rather a questionnaire, has to be filled in by both the parties. And as I said, right across the length and breadth of the country. So that is the that Rajneesh versus Neha affidavit, or that questionnaire, is the one that has to be filled by both the parties. It is not as if the husband can suddenly claim maintenance or the wife can suddenly claim maintenance. How does any judge decide whether a wife or a husband is entitled to claim maintenance? Because both sides may be lying through their teeth, and often happens in the court that both sides are lying. They're even lying on oath. So therefore, Justice Indu Malhotra of the Honorable Supreme Court has passed this judgment where she has said that let both sides come out honestly with their movable and immovable assets, their income, their 3 years passbook has to be filed, the income tax returns have to be filed, they have to show their list of dependents in their family, all those kind of things, they have to come absolutely clean about all their assets. So on the basis of that Rajneesh versus Neha affidavit, which is applicable all over India, the courts can decide at the time of passing any order under Section 24 or Section 25, whether it is filed by the husband, because Section 24 is only applicable during the pendency of the case. So there may be a case where during the pendency of the case, a party may not have asked for any interim maintenance. Section 24, as I said, is maintenance pendente lie, a Latin word which means during the pendency of the case. Section 25 is applicable as a permanent alimony. So there may be a case where during the pendency of the case, the husband may not have asked for any, interim maintenance. But as in this present case, he has asked for maintenance after the divorce has been granted, and the wife had applied for divorce in this case. So therefore, how does the judge decide after so many years that should the husband get maintenance or not, or should a wife get maintenance or not? So based upon that Rajneesh versus Neha affidavit, the courts are now, having a very powerful mechanism to, decide, that what is the truth. They can find out the truth in this manner, that if any of the parties is lying, or concealing their assets. There is also a warning that if any of the parties conceals any of their assets and makes a false declaration, that person is made aware that this amounts to committing an offense of perjury under Section 340 CRPC, which is punishable for 7 years of jail. So it is a warning to both the parties.
Absolutely. Both of you, Rekha and Amit, it's been a pleasure talking to both of you. Thank you so much for your time.